Hello friends, welcome to Khatri Steno. Be ready for the dictation without any stop and non-stop dictation for 10 minutes. Ready? Start. To appeals arising out of SLP number 23952 96 and SLP number 5570 97 are against the judgment dated September 28, 1994 of the Punjab and Haryana High Court in a batch of writ petitions numbers 5985 94 12105 94 and others. By the impugned judgment, the High Court had cancelled the appointment of 7737 candidates for the posts of different categories of teachers, which was over and about 2461 such posts which had been advertised for being filled up, while SLP number 23952 96 is barred by limitation of 673 days. SLP number 5570 97 is barred by 756 days. As we will presently see, there is no sufficient cause to condone the delay, and rather the appellants have acted as opportunists in coming to this court. Two more appeals arising out of SLP number 11939 97 and SLP number 562 97 are against two other judgments of the Punjab and Haryana High Court in different writ petitions, but challenge again is in effect against the judgment dated September 28, 1994 of the High Court mentioned above. These two SLPs are though within the period of limitation. The state advertised on August 19, 1992 for filling up of 2461 vacancies of teachers, but between this date and June 22, 1994, when the interview process was completed and postings were made, 7737 posts of various categories of teachers had become available for appointment. The state government, keeping in view the interest of the students, filled up all the available posts of 7737 out of the applicants who had applied against advertisement published on August 19, 1992. This action of the state government was challenged in batch of writ petitions in the High Court by the petitioners, who claimed to be higher in merit than those who were appointed against 7737 posts. As noted above, the High Court, by its judgment dated September 28, 1994, quashed the appointment of 7737 candidates and upheld the selection and appointments of candidates up to the number of posts advertised. Aggrieved by this judgment of the High Court dated September 28, 1994, some of the candidates whose appointments had thus been set aside filed special leave petitions in this court, these being SLP numbers 11728 11773 95, which were dismissed on May 1, 1995 by the following order. A review petition was also dismissed by order dated February 7, 1996. In our view, therefore, the judgment of the High Court dated September 28, 1994 became final and could not therefore be subject matter of appeals arising out of SLP numbers 23952 96 and 5570 97. These appeals are also by candidates whose appointment had been set aside by the High Court being over and above the number of posts advertised. The state government, it would appear, accepted the judgment of the High Court as it did not come up in appeal to this court. The matter, however, did not end there. The state government, after the judgment dated September 28, 1994, took a decision that the candidates who were selected in order to merit and whose appointments had not been approved by the High Court might be appointed on ad hoc basis for 89 days at a time, and that this would be a stopgap arrangement, and that the process of further recruitment must might be restarted by inviting fresh applications through advertisement. This action of the state government was again challenged in various writ petitions in the High Court, being writ petition number 18331/94 and batch of other writ petitions. These writ petitions were disposed of by order dated March 28, 1995, and the action of the state government giving ad hoc appointments on 89 days basis was upheld, but at the same time the High Court issued various directions for filling up future vacancies. It is, however, not necessary for us to set out those directions. The High Court, in its judgment dated March 28, 1995, noted an order dated January 10, 1995 of another division bench in civil writ petition number 14347/94, where also the High Court had directed the state government to complete the fresh selection process and in the meanwhile allowed services of candidates on ad hoc basis to continue till the availability of candidates selected on regular basis. We may also note that contempt proceedings were initiated as the state government did not fill up future vacancies within the time framework set up by the High Court to complete the fresh selection process. The High Court, however, extended time for the purpose and fixed a further date after which the ad hoc appointments of the candidates would terminate. The appellants before us are those candidates whose ad hoc appointments had been extended from time to time till regular appointments were made in terms of various orders of the High Court. Appeal arising out of SLP number 562/97 is against the judgment of the Punjab and Haryana High Court dated October 21, 1996 in civil writ petition number 16819/96. In this writ petition, there were 923 petitioners and they had claimed regular appointments on the basis of their selection made in pursuance of advertisement dated August 19, 1992, though they had been appointed on ad hoc basis in terms of the decision of the state government after the judgment dated September 28, 1994 of the High Court. In this petition, the High Court held that earlier challenge of the candidates suitably selected from regular to their ad hoc appointments had failed in civil writ petition number 4623/95 decided on April 27, 1995, and that there was no ground now for interference and that the petitioners would continue as ad hoc teachers etc. till regular appointments were made. Appeal arising out of SLP number 11939/97 is also against the judgment dated December 17, 1996 of the Punjab and Haryana High Court in civil writ petition number 1382/96. In this appeal, there is only one appellant, and the issue involved before the High Court was different inasmuch as he had contended that he, being number 6 on the wait list of lecturers for a particular institution, and claimed right to appointment when one of the candidates selected did not join. This plea was negatived by the High Court in view of the judgment dated September 28, 1994, which is being impugned. The High Court also held that the petitioner had come to the court too late and that he should have filed the writ petition either in 1994 or early 1995, but he came to the court only in September 1996, by which time the select list had lapsed.